Friends, we are going to discuss a case relating to Telangana state. Anyway, it's applicable in Andhra also, since previously we were in the combined state, and it is applicable to both advocates and also to the police officers. Right. So, the Telangana High Court Justice Sri P. Naveen Rao, while delivering a judgment on a petition filed in case of a disciplinary proceeding, he has given orders to the DGP and also to the Chief Secretary to warn the police against mentioning the names of the sexual offense victims. So, never they should mention the names of the victims. Already there are in the Indian Penal Code, you may be knowing the provisions, section 166A. It says whenever the victim of a rape alleges the so-called sexual assault, the police officer should go to her spot, he has to record her statement, he has to reach the case. If he fails to do the same, then he is liable for punishment under section 166A IPC. Second is disclosure of the identity of the victims, section 228A. So even during the course of investigation, at the stage of FIR itself, if anybody discloses the identity of the victim, then he is liable for punishment under section 228A of the IPC for about 2 years or fine, things like that. 228 IPC is also there. So that's why we call Nirbhaya case, very recently Disha case, we don't mention the names of the victims because the trauma their family will receive is more than the disclosure of the name. When once the name of the disclosure, definitely even we used to see the rape victims, even the own family members, they used to look down upon them. They were not allowing them to lead the normal life. When once it's subjected for a rape, of course, gone are the olden days. Nowadays situation is not there anyway, but still the family will be ostracized. The woman will be victimized. Therefore, you should not mention the name of the victim. Now, so Supreme Court has decided a case in 2018 itself. That case I will tell you. Nipun Lakshmikant, I will tell you there. Then basing on that case only, this judgment has come into existence. Actually, it is a typical thing. So before Justice P. Naveen Rao, one Mahapatra, his name is Kedarnath Mahapatra, he filed a writ petition before the justice saying that he was suspended from the Kendriya Vidyalaya. He was a principal, former principal of Kendriya Vidyalaya in Rachakonda police outskirts of Hyderabad city. So, basing on the allegation that he called a girl child and he has sexually advanced towards her, he was placed under suspension. Of course, criminal case was also registered. So, in the criminal case, he got bail. Now he says, since the disciplinary action has not been taken for the past 2 years, he wanted to quash the so-called disciplinary proceedings, as on the same matter a criminal case has been registered. Actually, this is the averment of the petition, writ petition filed by Kedarnath Mahapatra. Right. Now, what does the record say? The record says, of course, now we are coming to the criminal aspect. So the record says that on 28/10/2017, 28/10/2017, the principal, that means here the petitioner or Kedarnath Mahapatra, he called the 14-year-old 9th class student into his cabin and made sexual advances towards her. Right? No doubt she might have given a complaint. Basing her complaint, the police, Rachakonda police, they registered an FIR under POCSO Act, Prevention of Children from Sexual Offences Act 2012. Right, since she is a child, 14 years already told you. Right, now they have arrested the accused and he was sent for remand. He was in judicial custody for some time. That means more than 48 hours. Later, of course, during the month of November, this incident happened in October. During the month of November 2017, he was let out on bail. Of course, this is one part. So, since he was in judicial custody for more than 48 hours, and since he was involved in an incident of moral turpitude, calling a student just like his daughter, calling a student is to his chamber and advancing towards her. So disciplinary action also initiated against him, and he was placed under suspension. Right? But this suspension was not decided. That means the department inquiry was not so far completed and no action was taken. Now he has of course submitted so many Supreme Court judgments. There are judgments on either side. So since the fact is on only the fact is based on only one thing, that means he called her and he made sexual advance towards her. A criminal case has been registered on the same facts. Then what is the purpose of disciplinary action? But so many people, of course, there are so many decided case laws that the disciplinary action decides the basis on the preponderance of facts, whereas criminality or criminal case depends on the evidence part. So both of them are separate. This is administrative action, this is legal action. Both of them are separate. So legal action is separate from so and so. But still this man has, of course, he wanted to try his luck and filed a writ petition. Right? So now the petitioner filed the petition to set aside and quash the disciplinary proceedings. Already, please remember, disciplinary proceedings normally they should be completed within 6 months, or if necessary, if they are not, they have to prolong it. This person has to be given 75% of the substance allowance, that is salary. Of course, they have to complete it. There may be so many reasons for not completing it. 2 years after all is not a great period, right? So the judge, after seeing the records, he noted that it is neither advisable nor desirable to defer the disciplinary proceedings as 2 years are completed. Of course, definitely the advocate for the school, for the government, he might have stated that the disciplinary proceedings would have been completed, or in the final stage, like that he might have told. So anyway, the Honorable Court is also opinion that the petitioner is liberty, he is set out on bail, he is moving freely in the court, in the society. Therefore, he can defend himself in the domestic inquiry. He can appoint a good lawyer, he can attend the inquiry, get the cases adjourned time to time and get it done. What is so great? So why should he approach the writ petition? This is one part. So now, here, the Justice P. Naveen Rao did not allow his petition of quashing the disciplinary proceedings. In this connection, please remember. So, the affidavits were filed both on behalf of the police and also on behalf of the Kendriya Vidyalaya. So, the affidavit filed on behalf of Kendriya Vidyalaya. So, it shows mentions the name of the victim, her father's name, class in which studying, our village, and the case record showed there all the details of the woman, right? Police, yes, they mentioned the name of the victim and her parents. Even the FIR itself they have mentioned. Even in the remand report they have mentioned. Even in the charge sheet they have mentioned. Of course, they think that it is their duty to do. Then the judge directed the DGP to ensure that the names and their family members are not mentioned in the record, because the case law, right? So therefore, this case law is Nipun Saxena versus Union of India 2018. In this case, so of course she is a victim, is a child. Victim is actually, the case was under Juvenile Justice Act, and at that time the name this case clearly shows that the name of the victim at any cost should not be published. It should not publish. The publisher will be, if it is published, you are liable for punishment under 228A. So the Supreme Court has given guidelines that whenever the police has to mention her name, they have to mention as X or Y, and that name also, or they can use some fictitious name, and that name also should not cause embarrassment to any community. While mentioning the names also, if you mention as Shastri Sharma, it will be dangerous. So that means the victim's name, of course lady's name, they should not be, so they have to take care and they have to mention a fictitious name. In that process, it is better to mention her name as X or Y or Z. Right. Now what happens? If the FIR, yes, they have to register the FIR. In the FIR, you have to mention the name. But the original copy to be sent to the court, and the other copies, you should not mention. You have to strike down the name, or you should not see that. You should see that the name is erased. The name should not appear. Not only her name, her parents' name and address, all these things should not be allowed. So these things should be sent in a sealed cover to the court. So in the remand report also, should the accused on so and so date went to X and committed sexual assault on her. The accused on so and so date, he called X to his chamber and sexually advanced to her. Like that only. X, like that he had to mention. They should not mention the name. Even in the charge sheet also, they should not mention the name. Normally this happens in USA. Victims Protection Act. Normally, if any victim is actually put to threat, they will mention like that, ex-victim like that, they will be saying. So now the Supreme Court also, in this case of Nipun Saxena versus Union of India 2018, they have given guidelines. Right? Okay, it's good. Now, Justice Navin Rao, he has mentioned these guidelines, and he wanted the DGP and also the Chief Secretary. DGP to warn or to direct the police to formulate certain rules and inform the subordinates not to mention the names of the victims even in the FIR, in the charge sheet, as well as in the remand report, and for that matter even in the affidavits also. Likewise, the Chief Secretary is asked to formulate guidelines to the of the Supreme Court and pass on them to the managements of all schools, colleges, along with the media also. The media also to comply with the instructions of the Supreme Court guidelines. Because the media, the so-called Kendriya Vidyalaya, they mentioned the names of the victims and the parents in the counter. So personal details of the students should be kept in a sealed cover and sent to the court. Here now, for the police officer, I want to tell you, here, what about the rights of the accused? Does the accused have not a right to know as to who is the victim who filed a case against him? Yes, he has absolutely got a right. I don't know. You have to consult your legal experts and better you consult your PPs and get to know of the guidelines in this case, Nipun Saxena versus Union of India. Because even in AP also definitely one day or other you will be asked in the same line. So better awake yourself and get your legal opinion. In my view, as per my understanding in the Nipun Saxena case, what they said is you register the original FIR, send it to the court. As regards the other copies of the FIR, don't mention the name of the victim. I am clear for that aspect. Anyway, better your legal experts are there, better you contact them. But here, the right of the accused also you have to discuss. And so, when once you are required according to section 206 CRPC is 207, you have to supply copies of the documents basing on which the prosecution wants to rely. In that, definitely you have to mention the name. I think it is a right of the accused. So here I want to tell you a small incident. Of course, already 13 minutes are over. So here what happened is a woman was actually sexually attacked in a video. She filed a case, right? So this sexual harassment video copy should be given to the accused, because during the trial he wanted to have a glance toward the so-called video, right? So if it is given to the accused, definitely he will make 1,000 copies and circulate them. But still the law requires that accused to be provided with all the documents, is it not? So in such a case, the court asked him to come to the court and it will be exhibited and he can see it and he can prepare his defense along with the lawyer. But the copy of the video will not be supplied to him. Then he has gone to the court. Yes, accused, he has got a right to see what is there. So this problem will also come in this particular incident, because unless he knows the accused, how can he defend himself? This is a point for question. Anyway, better you consult your legal advisors and enrich your knowledge, because for police officers it may be troublesome in the coming days, I am 100% sure. And once it was published in the Telangana court, came to the notice of the Telangana court, Andhra High Court also will not keep quiet, and this Supreme Court judgment definitely Nipun Saxena definitely applicable to everybody on the land of India. Therefore, better you consult your legal advisors and advocates also. Please read the judgment thoroughly, Nipun Saxena versus Sin of India judgment thoroughly, and also the directions given by Justice P. Naveen Rao in this regard. ఇదే తెలుగులో అంటుంటాం, ఇంకిపల్లి సుబ్బి చావుకు వచ్చిందని చెప్పి తెలంగాణలో కాందిరే విద్యాలయం వాడు ప్రిన్సిపాల్ చేస్తే చివరికి అది జస్టిస్ నవీన్ రావు గారి ద్వారా డీజీపీకి సిఎక్సికి అక్షంతలు పడే పరిస్థితి వచ్చింది. But anyway, please read the judgment and enrich your legal knowledge. Thank you very much.